And then you possibly will render a decision without any other submissions.
Correct. File them by 1 o'clock. What time is this?
My Lord,
this is the problem. You know, when council don't comply with the directions given by the court, we are put in a mess.
In the special circumstances of this particular application, could we possibly get till 5 and you can rule on it tomorrow morning? Because everybody is here in court today.
No. Tomorrow we are just going into full hearing. You know, we have several petitions.
Yes, my Lord.
Yes. So if we begin putting some matters which we should deal with today to tomorrow, we are not going to move.
We pray for 2 o'clock then, my Lord?
File by 2 o'clock.
Most obliged.
Yes, file by 2 o'clock so that, you can bring them in to our chambers.
Most obliged, my Lord.
Yes. Yes, Mr. Ndubi, is
yes, my
your colleague here now?
Yeah, my colleague Judy is here now.
Yes.
We'll be ready to proceed.
Okay.
Yeah.
Sorry. Good morning, my lords, my ladies. I apologize. We had a small accident coming to court. But I'm ready to proceed. Which ones?
With the 2 applications?
With the 2 applications, yes.
Very well.
Subject to your directions.
Yes. Mr. Ngatia? Yes. 10 minutes strictly.
Before my time starts, in respect to the application Mr. Paul Mwangi was talking about, we served Mr. Awele yesterday at 5 or 6. And we have shown him an affidavit where he signed. But in respect to the application, I'm now going to argue.
Just a minute. Mr. Wele, you were served with that application?
Yes, my Lord, I've just received confirmation from my office that you've served, and I believe that's what Mr. Mwangi has confirmed, that we were served.
Then is there any reason for us to give you time up to 2 to file? You should have filed by now.
My Lord, we were served, as my learned senior has stated, he served us at 6 yesterday. In my
Yes?
Yesterday, at 6. I have just received confirmation this morning from my office that the hard copies were served, but we were served with the soft copies.
That's not our problem. Yeah. You know, in the situation we're working in, if you come here and tell us that the documents were served in your office, you don't know about them, that's your own problem. Your office is supposed to know the urgency of these matters and bring them to your attention. I told you we were here close to midnight last night. So you can't tell us that. Mr. Mwangi, if you don't file your reply by 2 o'clock, as we have said, we'll make a determination even without that.
My Lord, the reply will be available at 2. Most obliged, my Lord.
Thank you.
Also, I still have a difficulty because the scrutiny application was served on us at 6. We worked until midnight so that as to have affidavits here. So if Mr. Mwangi is to file after we have argued that application, I won't have an opportunity to comment on whatever other arguments you come up with. I would rather, my Lord, that we finalized with everything formally and regularly in open court. The minute you give counsel an opportunity to then file other documents that we don't have a chance to look at, it becomes very difficult on our part. We would rather do everything openly in court. By the time we leave, we know the court has all our arguments at the same time, at the same place.
Mr. Ngatia?
Yes, my Lord.
The application Mr. Mwangi is referring to,
yes,
is the one where, is it you have applied to strike out NASA?
Precisely.
And they were served?
And they were served yesterday.
Yes.
Yes.
The one for scrutiny is a different application.
I am using it as an analogy.
Okay.
Because I was also served at 6.
Yes.
I worked until midnight to be able to get an affidavit before you today.
Okay.
So nobody is asking for to file other documents after today's session.
Yes.
So before I leave here, it will be best I can be able to report to my team that all these applications were either argued or the pleadings have been exchanged, and we only come in the afternoon for a determination.
Though, my Lord, with respect to what Mr. Ngatia is saying about scrutiny, we do not have his response or affidavit that he may have done up to midnight. What we have is the application to strike out, but we have not been served with the response to the...
We are serving you.
We haven't been served. You will be serving us. That's all right.
Yeah.
We had to work until very late. It's our business to work until very late.
Very well.
Yes.
So can we proceed?
We can...
May I just make a small comment? My Lord, according to your practice...
If you want to be on record...
My Lord, according to your practice directions issued on the 7th of November 2017, on petition number 4, all applications by all parties were to be filed and served by noon yesterday.
Yes.
And so the argument by my learned friend that if we file our response late, and so they will not have an opportunity to respond to any issues that we may raise, I don't think is valid, because they themselves served us almost 5 hours after the time that you provided for all parties to file and serve applications. So I think because we were served yesterday at 6, I think it is only fair that we leave this matter rest with the directions that you've issued, that we just file our response by 2, and then you determine the matter based on the responses that have been filed, or the documents that have been filed.
We have already determined that. As I've told you, if we wanted, we would have said all these applications have been filed out of time, and we are not listening to them. Is that the situation you would have wanted? We have allowed, we are hearing them, although they are filed late. So let's make the best of the situation. Thank you.
My Lord, we go to the first application by the third respondent, which is to expunge 5 internal memos from the record. Those internal memos, my Lord, yes, there are 5 internal memos which we have applied to be expunged from the record. There is an affidavit in support and written submissions. Ms. Melissa Ngania will make the presentations on behalf of our team.
My ladies, my lords, the application before you is seeking to strike out and expunge the memos as pleaded in prior 1 of the application before you. The basis of seeking this request is that the memos were unlawfully and illegally obtained by the petitioners. My ladies, my lords, Section 27 of the IEBC Act provides for management of information. At clause 3, at clause 27.2, it provides for how information should be obtained from the Commission. It says a request shall be addressed to the Secretary or such other person. My ladies, my lords, in the memos that have been annexed in the petition before you, we see no such request to the Commission. The markings on the memos are clearly identified as internal memos. Without such request, a conclusion can be made as provided under Section 27 that such request was never made and therefore they are unlawful. My ladies, my lords, we would pray that they be expunged and not used in these proceedings. The use of them brings into jeopardy, first, the independence of the Commission to conduct its business. Article 80 of the Constitution provides for the independence, 88 of the Constitution provides for the independence of the Commission to dispense its business in providing a fair, credible elections. It is the song that has been pleaded in this petition. If that boundary is not drawn, then it will open the Commission to interference by parties who are actually players in an election. Furthermore, my ladies, my lords, the third respondent is a party herein. Using of this information is to the detriment of our clients. Article 50 provides for the right of fair hearing. This is information that is not in the public domain, but it has been come and challenge the election of our clients. We therefore pray that it be expunged from the record. My lords, if the Commission wanted the information to be within the public domain, then it would have published it in its website as provided under 27(1). The failure to provide that, it therefore means that it is not a public document, and that is why the right to information provided for under the Constitution is being provided for under 27(3). The Commission put that in mind, that people need to access information, and that is why we have Section 27(3), which says request for the information that you want to use. My ladies and my lords, that would be our reason why those documents should be expunged. Unless my ladies and my lords have any question, that will be our submission in respect to that application.
Thank you very much. Thank you very much.
I'm most obliged.
Yes. Mr. Ngatia, do you want to argue the other one so that Ms. Soweto can answer both of them together?
Yes.
Yes. I suppose that's okay with you, Ms. Soweto?
Yes, sir.
The second application, my lords, by the third respondent is seeking to strike out certain documents that were part of the petition. The deadline for filing the petition was 6th October. Those documents were part of that petition, but they were filed on 7th November, one day after the constitutional timeline. The fact that they were part of the petition is beyond argument. They are annexures, volumes, part of the document. I go volume 1 is part of an affidavit that was sworn by the first petitioner. The same is true for the second one, and the next one, and the third one. All these documents, my lords, were part of the petition. They were filed out of the 7 days. My lords, I do not need to overemphasize the fact that Article 140, Sub-Article 1, provides that a petition must be filed within 7 days. It is beyond argument the 7 days were to expire midnight on the 6th of October. So we do not have problems with calendar days. What the problem is, my lords, is the late filing of these documents which are part and parcel of the petition. In addition to that, my lord, the second prayer is seeking an affidavit that is referred to in paragraph 76 of the first petitioner's petition. My lords, when you go to paragraph 76 of the first petitioner's affidavit, there is reference to an affidavit by James Gondi. Gondi is Ngondi. That affidavit, even today, has never been filed or served. So that affidavit, my Lord, we still retain it in that affidavit. The reference to it is still there. It causes confusion to the court, if I could say so with respect, because when you retire to write the judgment, you'll be looking for an affidavit which has never been part of the record. Also on our part, my Lord, we must try to have a complete answer to the petition. It causes us difficulties that there is reference to an affidavit which is actually not part of the record. So the request to strike out that paragraph is to bring, so to speak, the reality with what has happened, which is that paragraph does not exist. Prayer number 3, in the event, my lords, that you allow prayer number 1, which is to remove all the documents that were found out of time, then certain parts of the first petitioner's paragraph will be struck out, which is paragraph 74 and 75. The reason for that is because they speak to the documents we are applying to be struck out. Paragraph 74 and 75 speak to the paragraphs we have applied to be struck out. Equally, my lords, paragraph 30, 31, and 61 speak to paragraphs or documents that we have applied to be struck off. Sorry, my lord? 30, 31, 61 of Billy Atudo's affidavit, they speak to the documents that in prayer number 1 we have applied for them to be struck out. My lords, our application is supported by an affidavit, and we have also done written submissions. In the written submissions, my lords, we have referred to numerous, not numerous, but quite a number of authorities. I would wish, my lords, to emphasize the fact that these constitutional timelines do not call for extension. These are timelines set in the Constitution, and in our view, do not permit extensions as we understand them under domestic law and regulations. My lords, we have referred to an authority, a Court of Appeal decision in paragraph 4 of our written submissions, the Waitito judgment. We have also referred to other judgments, and, my lords, the totality of these judgments is that when statutory timelines have been set, the court should not entertain requests for extensions of time. I say all that, my lord, to preempt a request which has not been made. It is not a request before you to extend time. There is no such request. My lords, equally, it is not a request by the petitioner, as far as I can see, that those documents were filed within time. As a matter of fact, no defense has been filed to this application. My lords, I would therefore request you, in tandem with so many other judgments we have referred to in our written submissions, to find in favor and to allow us our request, which is all those documents in prayer number 1 be struck out, and then we regularize the affidavits by striking out certain paragraphs that speak to those documents. My lords, that will be all. I do not need to run the clock down.
Thank you, Mr. Ngate.
Thank you, my lord.
My lords, I thought we would respond briefly. The first respondent. Our respondents in this matter. The document touches on us.
Very well, Mr. Kimani.
Yes, Kimani Mohoro. I appear with Mr. Sisule, Wambua, and Mr. Morogo.
Just a minute.
And I'll be very brief, my lords.
Mr. Kimani,
Yes.
you can take 5 minutes.
I'll be brief. Maybe
Very
more
well.
than 5 minutes.
Please.
I'm usually brief in what I do.
Okay.
Thank you, my lords. My lords, on the first part of striking out, we do not agree with the third respondent and will not support that line. However, on the issue of expunging the letters, we do join the third respondent's concern and state that these letters are selectively introduced, illegal letters that are selectively introduced. For example,
The memos.
the memos.
Yeah.
You have a memo from the chairman, but you have a memo in response. This is selective. This is creation of a narrative. And this court should abhor or not allow itself to be dragged into leaked memos, which are not conclusive. That's all, my lord.
But with regard to the striking out of the volumes filed late, you
I said I have no objection to that.
to them being retained.
No.
To the
Striking out of?
those documents which were filed out of time.
I have no objection to that.
Objection to what?
To the application. No. I will not support that. That's what I say. The application to strike out.
You're not
I'm not opposed. I'm opposed to the application to strike out those documents. I'm very clear on that. I think somebody's trying to confuse me here. Thank you.
Mr. Mohoro, sorry, CJ, Mr. Mohoro, it will help to say why. These are documents that he says were filed out of time, they affect you, and you're saying you have no objection because?
My reasons are very clear, my lord. We have all had problems in filing documents. There's been a long queue at the registry. To be dishonest of me. That's all.
Ms. Tangatia.
Yes.
Just before Soweto responds, with regard to the application to strike out the volumes, not the internal memos.
Yes.
The one seeking to strike out the volumes.
Yes.
We want to bring it to your attention that each council filing a petition is supposed to file 8 copies for the court, apart from the ones they are going to serve other parties. Of the 8 that are supposed to remain with the court so that they are distributed with the judges, we have 2 which are complete.
2 complete?
2 complete documents, including these volumes you are seeking to strike out.
So, I'm fair. Let me get this. 2 complete out of 8.
Let me put it again. Out of the 8 sets that are supposed to remain with the court,
Yes.
one for each judge, and of course another 2 for the registry. 2 of them
Were complete.
are complete.
I agree.
They were filed with the documents, even the volumes you are seeking to strike out. So that's the position. Would you like to respond to that before Soweto stands?
Very well. Nonetheless, my lords, even those, if they were complete, I doubt whether they would have the affidavit of James Gondi.
The affidavit of Gondi is not there. That one you are right.
So we could actually now deal with it on the basis James Gondi's affidavit not there at all.
Yes.
So the reference to it ought to be deleted.
Yes.
And then we come to 2 out of 8. This is a very poor mark. If only they did 2 out of 8, they had others to serve on us, so it will mean only 2 volumes were complete out of so many other volumes. My lords, that, in my estimation, is not forgivable, because it will mean even 6 of the judges had incomplete sets. The position may have been different if all the court's copies were complete. But to allow a situation where 6 are incomplete, the one for councils are also incomplete, my lord, that is not a position that will be forgivable.
Thank you. Ms. Soweto.
My lord, my ladies, I will respond first to the question of James Gondi's affidavit. That was inadvertent. We have no problem with that being removed from the court record.
So you are starting with the
Application to strike out
the volumes.
the volumes.
Okay. Go on.
In response to the application to strike out the volumes, my lord, the substantive law is Article 140 of the Constitution, as read together with Section 76 of the Elections Act. And the law says a petition shall be filed. That petition was filed. The basic requirement for the law is for a petition to be filed. The complaint that is before you is with regard to the service of copies of the petition upon the respondents. My lord, we filed a petition that was admitted by the registry and accepted as having been lodged within time. As a matter of fact, we were before the registry at 9 p.m.
Counsel, is the complaint late or lack of service, or is it that incomplete records were filed? So that you respond to the right application, what's the complaint that you're responding to?
The complaint, we filed a petition on the 6th of November 2017. We also brought 16 copies of the same. My lady, at the time of filing, by the time we're leaving the registry at about 1:24 a.m., not all copies had been stamped by the registry. Because of the late hour, the registry did request us to come back at 7 a.m. so that we could verify all the documents that were before them. We were ready to stay there until all the documents were stamped. The assurance that we also received was that because the petition itself had been filed within time, the other documents should have been stamped the same day the main petition was filed.
Let me rephrase this. The Honorable the Chief Justice has said out of the 8 copies that you are supposed to leave with the court, 2 are complete, 6 are not. And I think that's a complaint. Is it not this side of the team? Yes. That certain documents, which they now want us to expunge from the record, were not included in the volumes, whether they were stamped on the 6th or on the 7th. So are you responding to their concern? What to you is the petition? Maybe let's put it that way. What is the petition?
My lady, the petition is a complete set, a complete record of the petition.
Absolutely.
For as long as, yes.
So, there is the petition itself, which is a standalone document.
Yes.
Then there are 8 copies, all right?
Yes.
Inside those copies, certain documents are missing. And it is those missing documents that were not in the original one, unless I have not understood this.
I think there may have been a misunderstanding. When it is said that there are 2 complete records, it means it is 2 complete sets of the petition, volume 1 to volume 16 of what we filed, all of them stamped 6th of November 2017. So it is not that there are missing documents. It is that when the documents were delivered, in the process of verifying each document against the 2 complete volumes that you have, some documents were delivered. In fact, not delivered because we had to go back with them, were brought back the next morning to complete the process of verifying each document against what we have given to the court, the 2 complete volumes.
Ms. Soweto.
Yes, my lord.
We want you to be candid because yes. The information we have from the registrar is that the volumes brought on 7th were not brought along with those brought on the 6th. The registrar is here. You want us to go into that?
My lord, the volumes that were brought on the 7th, because there were some volumes which even what was given to the court other than the complete volumes, and I can say it was volume 10A, 12B.
No, please answer the question.
Yes.
Did you come with everything on 6th?
On the 6th,
Did you come with everything, all the volumes ready there, and the registry got tired of stamping and told you, come tomorrow for stamping? Why didn't you leave them there in the registry so that you just come to the following day for verification and stamping?
My lord, when we came on the 6th, we came with 2 complete sets of the petition, and we kept bringing the others as these ones were being received in sets. It is when...
So you came with 2 complete?
We came with 2 complete sets.
The others, you were coming with them afterwards. That's why they were stamped on 7th.
My lord, not quite, because I was at the registry. We came with all the documents other than some that were not being brought. And some were being brought, yes. As these ones were being stamped, were being allowed to walk in, we carried them. Because it was going to be a long process. Not everything was put in the registry in one place at the same time. That we would admit. But the 2 complete sets of the petition, which is the basic requirement, was before the court, filed on time.
That's all very well. That's all very well. And we are the first one to acknowledge that.
Yes, my lord.
The question I asked you.
Yes.
did you have all your documents in the registry before midnight on 6th?
No, we did not. We
Yes.
did not have them.
Some you came with the following day.
Some, yes. The only reason they came the following day is because we were stopped from continuing the process once we were there after midnight. Because we had said we are ready to finish the process of having our documents received that same night. The first petition was received at 11:45 p.m. We were there at 9 just to verify volume 1 to volume 16. It took 2 hours. At 11:45 p.m., the court acknowledged that we had filed a full petition, a proper petition, and started looking at now the other documents so that we could provide 8 complete copies and then the other 16 copies.
Olekewa, stand up. You were the one receiving these documents. Yes. Were they all complete? And you were tired of... what is the position?
Only 2 complete sets were complete.
Sorry?
There were 2 sets which were complete.
Yeah.
Then the other ones, they were prepared. They brought the following day.
So those others were brought the following day?
You are tired, you have to go to come tomorrow. We did not tell. They left at their own choice.
Oh my Lord, I delivered the second copy myself and went back for the other. What I can say for a fact, and I think this is embarrassing, is that the deputy registrar, who is my friend, was actually not in the court, in the registry at that time when I was there. He may have been at different times, I don't know, but the matter of fact is, as stated by my colleague Julie Soweto, is that we delivered the first set, and it took very long to verify. There are huge bundles, and we kept producing and bringing them. In fact, when I was supposed to come with the last batch in my car, I called Edgar Kavulavu, advocate, and Julie Soweto, who were in the registry, and they said they have told us to come tomorrow, you don't have to come. That is a matter of fact that I can attest to.
Very well, we will decide.
Thank you.
Yes.
My Lord, in any event, the question of the copies being stamped is a procedural technicality. There is no prejudice that is suffered by any of the parties. Particularly when the basic requirement is met that a petition was filed in time. Our duty is to avail to the court sufficient copies of the petition and to avail to the respondents as well sufficient copies of the documents that were lodged as the petition. For this particular argument, we will urge the court to apply Article 159(2)(d), that justice shall be administered without undue regard to procedural technicalities. This is a procedural technicality. Furthermore, my Lord, the purpose of having the document stamped, each copy, is to ensure that all parties have the same document across board. It is not the stamping that is in question. On the second application, which is the application to the second application is the application to strike out certain documents on the basis that they were illegally obtained. We oppose that application. Firstly, my lords, the third respondent cannot be seen to be the one arguing that documents that are not its documents should be struck out. The third respondent has not shown what prejudice they would suffer from those documents, and in what capacity they seek to protect the first and the second respondents with relation to their own documents. If these were the third respondent's documents, then they would have had a basis to make that argument. They do not have that basis. Secondly, my ladies, my lord, the documents that are sought to be struck out are documents that are in the public domain. They are documents that have been circulating widely, have been publicized broadly, some with the implicit approval of the first and the second respondents. Those documents and their contents form a critical part of the grounds in the petition, touching on the independence, the conduct, impartiality and neutrality of how the first and the second respondents conducted itself and their affairs. My lord, the counsel for first and second respondents have argued that the documents have been produced selectively. We have made an application. This is actually part of the application for scrutiny for the first and the second respondents to avail all their documents, all the internal memos, all minutes of their meetings, so that we can have a full picture of what was happening. And so the argument that we have produced the documents selectively cannot stand when those are what the petitioners were able to find in the public domain. Thirdly, the considerations of public interest outweigh the third respondent's objection to these documents being considered or being looked at as part and parcel of the factors that the court must make a determination on in the petition. The spirit of Article 35 of the Constitution, Article 10, is one of transparency, sorry, my Lord, the spirit of the Constitution is one of transparency, and Article 35 of the Constitution acknowledges that every citizen has the right of access to information that is held by a public officer or institution. To this extent, the fact that the documents that we already have in our possession are in the public domain, they cannot or should not be removed from the court record and measured against the application to have all other documents produced before this court, then, my Lord, the public interest outweighs any right or any prejudice that the third respondent claims it might have suffered. Finally, the aim of these proceedings and of the court is to promote the values of the Constitution and the principles to advance the rule of law. If these documents, these memos, the communications between the respondents, what they have publicly put out there, help the court to arrive at a just and fair determination of the matters before the court, then the court must allow them to be part and parcel of the record of the court and of the petition. Much obliged. Unless there are questions for me.
Ms. Soweto, you have not addressed Section 27 of the IBC Act. You have not addressed Article 50, Sub-Article 4, which were raised by the applicants. It's important that you address us on those two provisions.
I beg your pardon, my Lord. I agree. In respect to Article 50, Sub-Article 4 of the Constitution, my Lord, just to read, Article 50 says, evidence that is obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be included if the admission of that evidence would render the trial unfair. Number one, we have not obtained this evidence illegally or in any manner that violates the third respondent's rights. Indeed, that is the argument that I made. The third respondent has not shown how his rights would be violated. These are documents that have been in the public domain. My Lord, and just to comment on the issue of the documents being in the public domain, some of those memos, even after having been publicized widely in the print and electronic media, the first and the second respondents did not come out to object to them or in their proceedings. Secondly, on the question as to whether they would render the hearing of this petition unfair, that is a question for the court to consider. You have not been shown how the documents would render the hearing of this petition unfair. And then thirdly, common law principles which our courts apply show that evidence is, even if illegally obtained, which we deny, is admissible if it is shown to be relevant to the matters before the court. On the question of Section 27 of the IBC Act, the first requirement under Section 27 is that the Commission is under a duty to publish and publicize all important information within its mandate affecting the nation. That is the basic requirement. Subsection 2 addresses where a citizen requires that information, even without the IBC publishing it or publicizing that information. Therefore, my lords, the requirement that subsection 2, the request for the information, whether made or not, does not nullify or change the fact that IBC itself is under a duty to publicize and publish information within its mandate that affects the nation. This again is in keeping with the principle of transparency and openness. The questions before this court are such that it is important to see the transparency and the openness within which the IBC operated.
You should wind up, Miss. Your time has run out.
My lord, unless there are other questions. And then finally, as I'm reminded by my senior, the IBC has a positive obligation and duty to provide information and access to its documents and to its internal workings. That will be all.
Mr. Ngatia, please, 2 minutes.
I'll be very brief.
Yes.
I think my learned friend took twice as long as we did, but we'll not. I'll be very brief. I start with the second application. This is the documents that we are seeking to be removed. The first question is, what is a petition? The answer is provided in your regulations, the Supreme Court regulations. Definition section defines a petition to include an affidavit accompanying the petition. Rule 6 provides in very clear terms petitioner has an obligation to file an affidavit at the time of filing the petition. So to the question, what is a petition? The petition includes the affidavit and all the annexures to that affidavit. Second question, was a complete petition filed before the constitutional timeline? Answer is, at the very best, 2 sets were filed before the deadline. The set served on my client, the third respondent, contains documents that were filed after the constitutional deadline. Can we close our eye to it is the third question. The third respondent cannot close his eye to an infringement of a constitutional timeline. It is on that basis that we say the prejudice includes, my lord, the fact that you are now being requested to turn a blind eye to the fact that indeed the petition was filed out of time, and instead of the petitioner filing an affidavit to explain all the matters that my learned friend tried to explain, statements are being now made from the bar about what came at before midnight, what didn't come. All those, my lords, are not sufficient answer for a matter of this gravity. Those answers ought to have been in an affidavit, filed regularly, commissioned, so that there is material upon which this court can exercise a power, assuming the court has a power which could be exercised to enlarge time. As regards the first application regarding internal memo, my lords, we do not subscribe to a contention that internal memos are owned by IEBC, and because they are owned by IEBC, we should not complain. Our complaint is based on Section 27, that there is a legal way of seeking documents held by that public body. That legal method includes making a request for that document. It is definitely not an answer to tell us that those internal memos are in a market. We know of no market which has internal memos of IEBC. We do not know that market. And that market has not been defined. And it cannot be a market of illegally obtained evidence because it will still be illegally obtained evidence. The character of being illegally obtained evidence would have escaped if a request had been made and the documents had been provided. My lords, what prejudice do we suffer? The minute we allow, at the commencement of this hearing, evidence illegally obtained to be introduced, will contaminate the process. Will contaminate the process because then that will be a license to litigants to come with illegally obtained evidence or unlawfully obtained evidence and to pendle it before this court. But my concern is perhaps even a notch higher. Are these memos authentic? The only person who can provide that answer is IEBC. Because these are not letters, they are internal memos. Are they authentic? Can I stand before you and assume they are authentic? The answer is I cannot do so. I cannot assume they are authentic, and it is on that basis, my lords, that we request that all those memos be expunged from the record. This argument would have been totally unnecessary, my lords, and I'm sure you can see the last word I want to say, if a request had been made to IEBC for production of the documents. The most elementary answer would have been that either these memos exist or they do not exist, or for one reason or the other, we cannot disclose them. That was not done. Why was it not done? Is the question, my Lord, that the petitioner cannot answer. Why didn't they do such an elementary process of a letter and say, this is the letter we did, and then in abundant caution, we went to that market, wherever it is, to obtain them. My Lords, on those grounds, I would request you to allow both applications as prayed, because there is no answer to any part of the request that we have made. That's all.
Mr. Ngatia, before you sit down, we have told you we have 2 complete sets.
Yes.
If we agree with your application with regard to the volumes that are filed late, what do we do with the ones which we have?
I go back to the Constitution, my Lord. The Constitution does not allow 2 or 3. It allows all the petition, the complete petition, to be filed within that timeline. And the complete petition would be, if I were to go numerically, the 8 required for the court, and maybe an extra 1 set for the registry, and the other copies for service. Because the set I've got to be served must be identical with the set that each judge of this noble court has. So it is not an answer, my Lord, that there could have been partial compliance.
So we strike out even the complete ones that we have, that were filed in time.
Well, the only way I can answer, my Lord, is I can only answer from what I have. And what I have, and I'm an integral party to it, is a petition with documents filed out of time.
No, take my word that we have 2 volumes, and we can give them to you to see.
I have no doubt.
Which were filed in time.
I have no doubt, my Lord Chief Justice.
Okay.
I have no doubt. But please see it from my lens, that the petition I have has that constitutional infraction, the infraction of documents filed out of time.
Thank you. Thank you.
Thank you so much, my Lord Chief Justice.
Okay, the next application, is it Soweto or Undubi? The one for scrutiny?
Yeah, she will argue.
Okay.
My Lord, can I address the court with your permission before my learned friend makes that submission?
Yes.
My Lord, and this relates to the time required to argue this matter. My Lord, you will recall that in election petition number 1, when a similar matter came up, and you delivered your ruling on dated 28 August 2017, that ruling was so pivotal that when you look at your judgment of 1st September, that election was nullified because of the scrutiny and the result and the judgment of 28 August. My Lord, from where I sit and where, in light of the fact that ultimately it was the election of my client that was nullified, this application is so pivotal again that we don't think, with tremendous respect, that 10 minutes is enough, especially in light of its consequences. My Lord, I petition your good office and the court that we be given adequate time. And my Lord, I don't read how many paragraphs in the final judgment you refer to this scrutiny. We require adequate time, my Lord, to argue this scrutiny.
What do you consider as adequate time?
Yes, my Lord, I don't want to sound out. 30 minutes will be fine. 30 minutes.
30 minutes for each?
Yes, yes, that. I don't know how long they will require. They may require less than myself. But for the third respondent, 30 minutes, my Lord.
Mr. Mr. Ahmed Nasir and Mr. Ndubi. You know, this is the problem council put us in. Ideally, Mr. Ndubi, you should have filed this application along with the petition, or a day after you filed the petition, so that everybody has time. We would even have made time to hear it before today. But you leave everything and you're filing it yesterday. So that is the problem we have. Okay, fine. We'll see. But please understand the time constraints we are in. Yes, I want so that none of you should repeat yourselves. Be concise and take as little time as possible. Mr. Weto.
May I also seek a clarification, my lord? I understand there is an application to strike out a party from the proceedings. Should it be that the application to strike out the party should be heard first before the application for scrutiny? Because a party who may not qualify to be a party then has no business with the application for scrutiny.
But Mr. Gatonye?
Yes.
The application for scrutiny,
yes,
has been filed by the petitioner.
Yes.
And it's directed at a particular person. Okay.
The application for scrutiny.
Then we have the application to strike out a party.
Yes.
Which, in my understanding, has been brought by the third respondent.
Yes.
So there are two different applications. So really, the order of priority doesn't matter.
My only concern, my lord, was in the event you are to uphold the application to strike out, you would have given a party the opportunity to participate in an application that goes into the essence.
The party whose participation is being sought to be struck out,
yeah,
is not the one that will argue,
yes,
the application for scrutiny. So it doesn't really. Your concerns are, I think, misplaced, Mr. Gatonye.
Yes.
So I think we should proceed.
Yes, Mr. Weto. We will give you 30 minutes, Mr. Abdunasir has requested. But if you can make it in 20 or less, we will be grateful.
My Lord, I do believe that we have filed written submissions in respect of our application for scrutiny. I think the challenge with all the applications, even though it is blamed on council, is the time. My learned senior was talking earlier about us not filing responses. They are there, but they are not before the court because of when we were served. So even the responses to this application have just been served upon us. We will simply make our application on the basis of what the law provides, because we believe this court has dealt very clearly and settled matters of scrutiny. My Lord, the application is the application that is before you, the application dated the 13th of November 2017. It is supported by the affidavit of the second petitioner. We are seeking the following orders at paragraph 3 of the application: that the second respondent be compelled to give access to and supply to the court and to the parties the following documents, information, and data that is in the exclusive possession of the second respondent. We're asking for copies of minutes, all plenary deliberations of the second respondent relating to the fresh election from 1st September 2017 to 31st October 2017, both days inclusive. We're asking for copies of all internal memos prepared, issued, and/or circulated amongst the commissioners and/or the secretariat staff of the second respondent relating to the conduct of the fresh election from 1st September 2017 to 31st October 2017, both days inclusive. We're also asking for the full and unredacted KPMG audit report on the voter register, including all sections of the report that have not been made publicly available. This should include the chapter on security and penetration tests on the register of voters. My Lord, if I may address you on the basis for that particular prayer, and on the basis of what this court has decided before, an application for scrutiny must be founded on the petition itself. These factors have been pleaded in the petition and form the grounds upon which the petition itself is made. My Lords, if we'll... A major ground of the petition is that the first and the second respondents did not operate within the law. We have made complaints and allegations that there was internal rife within the second respondent. There was infighting within the second respondent, matters that have spilled into the public domain have not been denied and are not disputed. My Lord, as an example of the matters that are within the public domain and which the first respondent or the second respondent cannot take back and now refuse to give access to their documents are, for instance, the public resignation of Commissioner Dr. Rosalind Akombe. When that matter came out publicly, the first respondent issued a public address admitting the matters that are stated in the memo by Dr. Rosalind Akombe, and therefore opening the matter up to the public for questioning. It is therefore only right or in the interest of justice that the parties should be allowed to have a look at all the deliberations of the first and the second respondents in their decision making, and to consider the issues that were publicly admitted, made available, or exposed to the public by the first and the second respondents. My Lords, the request that all the minutes be made available together with all the memos then takes care of the argument or the complaint by the respondents that there has been a selective production of evidence before this court. We want the full picture. On the prayer for the full and unredacted KPMG audit report on the voter register, my Lord, One of the grounds of the petition relates to the identification of voters by biometric means or alphanumeric. And these are matters that were covered in the audit report that was done by KPMG against the voter register. Those tests are relevant to the questions before this court in the petition. Prayer number 4 is that the second respondent be compelled to avail for scrutiny all the secure digital or SD cards from the KIMS kits that were used, unused, or expected to be used in the fresh election, whether deployed or not. My lords, the SD cards hold the information, including the voter register, the number of voters who turned up to vote. One of the questions that is before this court, or one of the allegations that has been made, is that there was tampering with the results and the returns that have been made by the second respondent. In support of the application, my lords, we have filed returns that were obtained by observers from the field, and which, in comparison to returns that have been filed or were publicly displayed in the public portal by the second respondent, are at variance. There are also returns that show alteration of the numbers. The only way to verify the accurate numbers of persons who were alleged to have turned up to vote or who were captured is in the KIMS kit, which is the primary instrument with the voter register. My lord, from the KIMS kit, or from the SD cards retrieved from the KIMS kit, we have already said we will be able to see the number of voters who were identified using their fingerprints, the total number of voters identified using Alpha Search, and the total number of voters identified using document identification. Together with this, this can be compared to the Forms 32A that we have also asked should be made available. As well as the original KIMS supervisor validation forms used on 26th October 2017. Those are the prayers at number 10 and 11. They go hand in hand. Number 4, number 10, and number 11. We are asking that the second respondent be compelled to avail for scrutiny and audit the results transmission system server logs between 22nd October 2017 to date. This is expected to show the number of KIMS kits that were functional on 26th October 2017, the logs from the KIMS kit showing voter turnout, because these can be compared, the time when results were transmitted, and any recorded incidents. My lords, again, this has been pleaded in the petition, and the evidence that has been placed before this court shows discrepancies, shows evidence of manipulation, and the only way to ascertain the true position or to verify the facts that have been pleaded in the petition is through a scrutiny and audit of the result transmission system server logs. Number 6, we have prayed that the second respondent should be compelled to avail for scrutiny all the secure digital SD cards from the KIMS kits, particularly of the following polling stations. Muranga County, we have listed 10 stations, and Garissa County, we have listed 19 stations. My Lord, attached to the petition, to the notice of motion, and also to the evidence in the petition, are returns, forms 34A filed that were obtained by observers from the field, as well as forms 34A that were posted in the public portal by the second respondent, which show discrepancies. In respect of the ones for Muranga County, my lords, the evidence that we have is that the numbers that are on those forms 34A do not tally with the numbers that were published in the forms 34B or in the portal by the second respondent. In respect of Garissa County, my lord, the forms that we have exhibited all show alterations that are evident by hand. Such that what was recorded in the forms 34A originally is not what was finally posted. By the second respondent. I'm just wish to point an example. My lord, at page 91 of the notice of motion, perhaps we could start with page 86. Page 86 is an example of a Form 34A from ASK Showground polling station. My lord, a casual look at the form there shows that the original number of the votes, for instance, that were given to the third respondent was 72, but a 3 has been added before the 72. At the end, we have total valid votes cast. The original number was 74, but the form that we have now shows a 3 has been added to make it 374. At page 85, a different example. It is clear that the result that had originally been recorded for the third respondent was 145, but the 3 has been overwritten to have 345. Similarly, in the total number of valid votes cast, at the end, you can see it was 148. The one has been altered to read 348. With the Garissa forms, that is the same case, where all the forms have been altered. The only way to verify the actual number of votes that were cast or recorded, or the number of persons who turned up to vote, is through a scrutiny of the records in the KIMS kits. For this reason, we are also asking, number 7 goes together with number 6, that alongside the scrutiny of the SD cards, the records in there, there should be a scrutiny and audit of the originals, Forms 34A and 34B, in respect of the polling stations that have been listed for Murang'a County and for Garissa County. My Lords, in light of what has been discovered in respect of Murang'a County and Garissa County, we have asked the court to conduct and allow for a random sample audit and scrutiny of SD cards from KIMS kits across all polling stations. We have listed those as Makadara, Navakolo, Mumias West, Mumias East, Wajir North, Wajir East, Tarbaj, Eldas, Wajir South, Balambala, Ijara, Fafi, Dadaab, Kitui Central, and Masinga.
We can see them. You don't have to read all of them.
Very well, my Lord. And my Lord, a random sample audit or scrutiny will allow the court to make a determination as to whether what has been shown, the discrepancies that are shown in number 6, were random or prevalent. My Lord, for number 9, we have prayed that the KIMS kits themselves be availed together with SD cards and the SIM cards for the following polling stations. They are 5. The reason being that the images that were transmitted or alleged to have been transmitted from those KIMS kits cannot and could not have originated from those KIMS kits. Those images we have given and shown in the affidavit are at variance with what is expected to be produced from a KIMS kit. Number 12, we have prayed that the second respondent do avail for scrutiny all original polling station diaries. Again, every incident is required to be recorded in the polling station diaries. For instance, where voters were identified using any other means other than their biometrics, that should be recorded in the polling station diaries, and therefore it is necessary to compare what is recorded in the polling station diaries with the returns that are filed and in the KIMS kits. Number 13, we're praying for a random sample scrutiny and audit of Forms 32A against the KIMS supervisor validation forms and KIMS kits records in SD cards in the respective polling stations. Again, the rationale for this is that there is supposed to be consistency between what is recorded in the KIMS kit. The Forms 32A should be there matching what is recorded in the KIMS kit as those who could not be identified any other way or through their biometrics. And the polling station diaries would also show the same record. We have prayed for all the original Forms 34A, Forms 34B, and Forms 34C. These are returns that, in any case, the second respondent is required to avail by law. And number 15, we're asking that the FTP server logs be availed. These will show the time the returning officers transmitted the Forms 30B and the user accounts that transmitted Forms 34B. As part of our evidence, we have shown that there were instances where returning officers transmitted results hardly 15 minutes after 5 p.m. Going by the second respondent's own manual of what should happen at the end of voting, it is not possible that results could have been transmitted, votes counted within 15 minutes, votes counted within 15 minutes of close of the polling station, things verified, and the results transmitted. It is for that reason that we ask the server logs be made available for scrutiny. Number 16, we're seeking the printouts and/or electronic copies of all the electronically transmitted results, including printouts of all copies of Forms 34B from the 291 constituencies. Number 17, we're asking for a certified copy of the voter register used on 26th October 2017. The reason for this is that the total number of voters that has been availed or made public by the second respondent has kept changing. There is therefore no consistency as to what is the accurate number of total of the voters that are registered. Number 18, we're asking that GPS coordinates for all the polling stations, including a certified list of the KIMS kits deployed and the serial numbers, as well as the name and coordinates of the polling station at which it was deployed, be availed. The mobile network operations base stations, the call detail records for the KIMS kits, the list of authorized RTS users, and the users' auditory logs from 22nd October to date. The service level agreements with Safaricom, Airtel, and Telcom, the transaction logs and the biometric statistics of all voters identified by the KIMS kits. My Lord, the rationale for the prayer under number 18 is based on the allegation that has also been made that polling stations were changed arbitrarily from where they were supposed to, from the gazetted areas. Again, With respect to, for instance, I wish to comment a little on the service level agreement with the various providers between Safaricom, Airtel, Telcom, and OT Morpho. These agreements will show what the various providers, what agreements was made with the various providers and what they were expected to deliver, to be compared to what the second respondent has made available. And then finally, we pray that in addition to facilitate the fast scrutiny of the logs and the data within the limited time frame available, that the court do make an order allowing for the copying of the logs and the data. My Lord, the concern is always time and practicality. By allowing for copying, this will enable the scrutiny of these documents and the logs go much faster than if read-only access is given. We are looking for ways to ensure that the court is able to conduct a scrutiny within the shortest time available. My Lord, the application just to conclude on the grounds as stated, this court has already ruled before that the basis for a right to scrutiny must be founded on what is pleaded, by way of the pleadings and the affidavits. Everything that we have prayed for is in our pleadings and is supported by the affidavits filed in support of the petition. And in the petition itself. My Lord, we refer you to this court's decision in the Gatirao Peter Munya versus Dixon Mwenda Kidinji case. We also refer to this court's decision in the Raila Odinga 2017 case, in which the court once again went through the grounds and the considerations for granting an order for scrutiny. Which is founded also on the Article 35 right that of the Constitution, that every citizen has the right of access to information that is held by the state and by another party. Section 4 of the Access to Information Act.
You should be winding up. Your time is up.
I will wind up, my Lord. And then finally, my Lord, the application for scrutiny is in line with the second respondent's obligation under Article 27 of the IBC Act, which is to publicize and publish information regarding its within its mandate, sorry. Just to read that properly, that the Commission shall publish and publicize all important information within its mandate affecting the nation. This is information within the second respondent's mandate. It is important for the determination of the matters before this and how it conducted its mandate on 26th of October, 2017.
Thank you. Before you sit down, Ms. Soweto, just for, you've talked about practicability. Where would the marked register be found? Under the diaries, the what? The election diaries. Where would they be found?
My Lord, in accordance with the second respondent's own directions to its returning officers, at the end of polling, the presiding officers are supposed to deliver the polling station diaries and these documents to the returning officers, and the returning officers deliver these also to the constituents, to the National Tallying Center. So we expect them to be here in Nairobi as part of the returns that were filed or submitted by the returning officers and the presiding officers. And my Lord, at the two application we have annexed, it is at page 125. It was a quick reference guide for presiding officers during the election. Page 125, it's at page 125. It runs all the way to page 144.
What is there?
It is a reference guide prepared by the second respondent for its presiding officers and what they should do. I'm looking to refer you I'm just looking for the page that shows what they're supposed to deliver, what each presiding officer is supposed to keep in a box, and what is to deliver to the returning officer, and which is then delivered.
Very, very well. You can do that in your rejoinder. Maybe the IEBC lawyer will tell us where those documents are. Unless you have anything else, I would be happy if you would sit down.
Very well.
Yes.
Thank you.
Thank you. Who is the first respondent?
Yes, my Lord, I'm for the first respondent, but since the ABCs want to explain what the documents are, and most of these scrutiny documents,
yes,
I would prefer that Mr. Gatonya has a first bite of the chair.
So you will submit for both the first and second respondent?
One or two comments, but the actual affidavit is by an officer of the IBC.
Very well. Mr. Gatonya?
May it please my lords, we do oppose the application for scrutiny as being...
Sorry, before you respond.
Sorry.
Is there anybody supporting the application?
Is there?
Anybody, any party supporting the application? Because of the time, because of the constraints of time, we want to limit this application to the two parties concerned. It is fair that way. Otherwise, we will be here and we will not be able to complete. Is that agreed? Yes, we limit it to the two parties and move on. Very well.
So, my lord, for the second respondent, we oppose the application as being misplaced, superfluous, and without merit. My lord, in opposition to this application, we have now managed to file an affidavit in response. I'm not sure, my lords, whether copies have been made available to you.
We look at them. Just move very fast, please.
All right, my lord.
Yes.
Yes. Now, we rely on this affidavit, and we would like to characterize it as very comprehensive in response to the prayer sought and the alleged facts in support thereof. I only wish to emphasize 6 matters in relation to this application on behalf of the second respondent. The first one, my lord, is that it is in violation of many of the decisions of this court that when an application for scrutiny is made, which application is a serious application, sufficient basis must be laid for that application. And there should be sufficient specifics in relation to the complaints made. My lord, when you retire and you look at the application, you'll find that it is made in very general and broad terms. And my lord, this can only be characterized, going by these well-known authorities read by this court, as a fishing expedition. That should not be allowed. My lord, there is also failure, deliberate failure on the part of the applicant to comply with the Section 27 of the IBC Act. That section, my lord, gives a person like the applicant to make an application to the IBC for documents, for information. My lords, the declaration for the president-elect was made on the 30th of last month. And from that point, my lord, no explanation has been given why this information, if at all it was required, had not been applied for. Indeed, my lord, we were served with the application yesterday. Why the long wait? It is, in our humble submission, an afterthought. And we will demonstrate, my lord, shortly, that it is being made for a collateral purpose, to show that the second respondent cannot comply with an order that may be made by the court to its disadvantage. I'd like, my lord, to make brief reference to paragraph 7 of the affidavit that we are relying on. Very brief reference, my lord. And, my lord, we're talking about the logistical problems that would be involved in the deployment, in the availing of the KIEMS kits that had been deployed. And, my lord, we would require budget for this to go to every polling station in the country. We would require logistical support to be able to bring up all this equipment and the retrieval process. And, my lord, according to our ICT expert, this could take even 2 weeks. Indeed, I'm advised this is a minimum period that would be required. I would also like to refer your lordships to paragraph 10. My Lord, there is a prayer that there should be a random audit and a scrutiny of STD cards and the KMS kits across all the polling stations in the country. My Lord, again, this is a very general prayer. And a very vague prayer. Who is to do the random sample and the audit? Where? Again, my Lord, there is no taking into account the financial and logistical problems involved in this kind of exercise. More so when you do not even come out clearly as to the person who you want to carry out this kind of an exercise. Again, my Lord, I am advised it would require quite some bit of time, about 2 weeks, to complete such an exercise. Yeah. Particularly, I am given to understand, my Lord, the retrieval is not an easy task, involving 291 constituencies in the country. My Lord, I move on. There is also the issue, my Lord, as to lack of good faith in making this application. Let me look at some of the aspects of lack of bona fides in making the application. In accordance with the Section 12, my Lord, upon service of the petition on the second respondent, it is required to file statutory forms within 48 hours. My Lord, we have done that. Those forms are not only filed, but they are certified copies of the forms. There is no word from my learned friend whether an effort has been made to have access to documents that are already with the court, and why the originals should be brought here. Has somebody examined the certified copies and doubted their authenticity? We are not being told, my Lord, as to why the originals should be produced. And has there been an effort, my Lord? Is there a letter written to court asking for access to these documents? No evidence, my Lord, that a request like that has been made by the applicant. But, my Lord, that's not all. This information, and you'll get this from our affidavit that is being requested, most of it was supplied through an affidavit sworn by the present deponent and which has been served upon the applicant. That information, my Lord, is now with the court and with the applicant. My Lord, if we were to have this application allowed and this tedious and arduous exercise carried out, my lords, it would affect in a most profound way the expeditious hearing of this petition, which has constitutional timelines. My Lord, those who sleep on their rights cannot wake all of a sudden and come and ask for exercise of certain rights that would prejudice the other side and the tribunal that is called upon to determine the issues in question. And I'm sorry to emphasize this again, no explanation has been given as to why documents were not requested in a good time after the declaration of the president-elect. My Lord, I do not want to go into the details of how we have answered every allegation in terms of the affidavit that was filed yesterday and the one that we have filed today. But, my Lord, when you retire and you look at those affidavits, the issues raised by the applicant are answered in full. And unless your lordships wish to ask me for any clarification, I'm quite happy to rest our case there. But there is one of our assistants who would like to speak to something. My learned friend, Mr.
Before he comes,
yes,
I had asked a question about where the diaries and
yes,
the marked registers
yes,
would be, or he would answer.
I'll tell you.
Okay.
Yes. My learned friend, Mr. Mahat, will address that issue.
My Lord, the Chief Justice and Associate Justices of the Supreme Court, to the question where are the polling day diaries kept, my Lord, the polling day diaries after the completion of the tallying and the counting of the election are sealed in transparent seals, and they are put into the ballot boxes, and the ballot boxes are sealed. My Lord, the effect of that is, if you were to order that those polling day diaries be brought, it will mean that it will be a logistical nightmare for the IEBC, because it will mean that we have to get almost 37,817 polling day diaries from all over the country for the people who voted in the polling station. So it is, and that is something that will take 14 days. My Lord, in reference to this application, we find this application to be very interesting because, my Lord, most of the information...
What about the original Forms 34A and Forms 34B?
The original Form 34A and Form 34B are stored at the Commission warehouses. But, my Lord, certified copies of the same have been provided to the court, and the same are available and have also been provided to all the respondents in a 40 GB electronic hard drive. We provided all that information.
Those warehouses are in Nairobi?
Those warehouses are in Nairobi.
Okay.
Those warehouses are in Nairobi. My Lord, to come back to the application, we find this application to be very interesting. Because if you look at the application for scrutiny, the facts that are raised in this application have already been provided, my Lord. We rely on the affidavit of Silas Njeru and the submissions therein. And if you look at the affidavit of Silas Njeru, my Lord, the first request that they are making relates to the ICT infrastructure of our client. The RTS transmission, and the SD cards. That information has been provided in an annexure SN1. In fact, if you look at the affidavit provided to this court of Silas Njeru, and you look at annexure SN4, there is a table of contents on the information that we have provided. The information that has been provided by the chairman to this court and also to the petitioners includes the EVID logs. The EVID logs that show the number of people who are authenticated by the KIMS. We have provided the network logs showing the people who access the network. We have provided the Apache server logs and that is in a 40 GB hard drive that has been provided to both the respondents as well as the court. We have provided the CDR, the call data records of all the service providers, which shows the KIMS GPS, which is the location of that KIMS kit, the time it's transferred.